Thank you very much for that introduction. It's a great honor to be here. This is my first time in Cambridge at all. You have a very beautiful city and university. If you follow copyright at all, it can't have escaped your attention that the community of copyright law scholars has been deeply polarized for the past 20 years. Some of us see ourselves as advocates for the undervalued interests of readers and other users. Others argue that we need to increase the copyright protection we give to authors. Somehow neither side gets around to saying, gee, both of those sound like worthy goals. And it's in fact gotten a little ugly. We have called each other bad names. Some of us have stopped reading the scholarship of scholars perceived to be on the other side. So I believe, or at least hope, that whole sorry era is almost over, or will be over as soon as we forgive one another for all the nasty name-calling. As concrete reform proposals have emerged from the muck, it's become increasingly clear that what was billed as a conflict between authors and users was never about that at all. Instead, what's been going on is a fight to the death among different intermediaries. So legacy intermediaries, by which I mean publishers, record labels, movie studios, are fighting with newfangled intermediaries, that is, online service providers, platforms, digital delivery businesses. And what they're really fighting about is who gets to eat the biggest piece of pie. So I think copyright scholars can safely leave them to work it out without our help. If the core question in the debate is whether the law ought to favor publishers over platforms or vice versa, first of all, the answer is unlikely to have any practical effect on the copyright ecosystem, and it's a much less attractive dispute to get worked up over. Neither side has much of a claim to the moral high ground. It's less interesting from a theoretical or policy perspective than many other problems the copyright system faces. So if the distribution of goodies among old-fangled or newfangled intermediaries won't have much impact on decisions surrounding the balance the law should strike between authors and readers, I think most scholars are going to lose interest in the details of this particular conflict. So after we get our feet extracted from all the mud we've thrown at each other, I expect the community of copyright scholars will move on to more interesting issues. And there are a bunch of them on the horizon. One that has captured my attention recently is the fact that for all the rhetoric about the central place of authors in the copyright system, the actual copyright system gives authors little power and less money. Now, this probably isn't the most important problem facing the 21st century copyright law, but it strikes me as one of the most interesting. And copyright scholars haven't given that problem sustained attention. Why not? So let me acknowledge my priors. 21st copyright law is a complex system with a bunch of interlocking, sometimes inconsistent purposes. I'd say the most important of those purposes are these. First, copyright law should encourage authors to create and widely disseminate works of authorship. Second, it should give them meaningful opportunities to earn money from doing so. And third, it should encourage readers, listeners, viewers, and other users to encounter, enjoy, and learn from these works of authorship. Okay, so we have other purposes to the system, but they're subsidiary. To hijack a turn of phrase popularized by Amazon.com's vice president, Russ Grandinetti, the only essential players in the copyright system are the authors and the audience. Now, copyright system needs intermediaries to distribute works of authorship to their audiences. and to channel the revenues flowing from the enjoyment of those works back to authors. But we can be, and I think we should be, agnostic as among competing intermediaries. The most important consideration is how well they accomplish their tasks of disseminating works to audiences and paying money to authors. So let's look at how they're doing at those tasks. How well is the current global copyright system working out for authors and for readers? So let me talk about readers first. I've spent much of my career arguing that the copyright interests of readers and other consumers are receiving too little attention. And I have real concerns. For one thing, at least in the United States, readers are paying for access to works by giving up massive chunks of personal privacy. For another thing, many copyright owners have succeeded, at least so far, in their efforts to nullify the legal rights that copyright laws give to users by purporting to bind consumers to overreaching end-user license agreements. I'm concerned that that will end up severely undermining the copyright system in the long term. Still, even with those problems, to the extent one of the goals of copyright is to give members of the public many opportunities to enjoy a large variety of different works in different formats at different price points, the current system is fabulously successful. Situation for authors, on the other hand, is much more depressing. The copyright system, in truth, has never been very good at either giving authors their choice of myriad channels for distributing their works to the public, or at enabling them to earn meaningful amounts of money from doing so. If an author's goals are to communicate her works to their best audience and earn money from doing so, her choices end up being narrowly limited. Even if she succeeds in disseminating her work to the best audience through the most suitable channel, she needs to accept that the intermediary who operates that channel will likely both control the distribution of her works and end up keeping most of the money. So in the 18th, 19th, and 20th century, I think this bargain probably seemed pretty reasonable. Paper was expensive. Mass distribution required a significant capital investment in paper, printing presses, bookstores, warehouses, trucks, movie cameras, communication satellites. It made sense in that context to expect that as the revenues from works of authorship flowed from users to authors, most of the money got diverted along the way to pay for expensive reproduction and distribution solutions. And the 21st century doesn't seem so reasonable. At least some popular reproduction and distribution alternatives are much less expensive than other sorts. Digital reproduction, digital downloads, digital streaming can be downright cheap. Indeed, the fact that anyone can afford to do that is said to be a significant driver of increasing consumer piracy. And by all accounts, the money attributable to the distribution and enjoyment of works of authorship is at an all-time high. But creators report they're being paid less, sometimes much less than they used to. So why? Some of the explanation might be due to the winner-take-all structure of many of the copyright-intensive markets. J.K. Rowling, Damien Hirst, Lin-Manuel Miranda have all earned a lot of money from their works of authorship. The majority of creators, in contrast, often regularly face the choice of either living perilously close to the poverty line or working at a day job to support their families. But that's not a new thing. If creators are actually earning even less than they used to, there are other factors at work. So it's a complicated problem with multiple causes, But one of the causes is that many of the intermediaries in our story have recently figured out ways to earn more but pay creators less. I alluded earlier to the conflict between old-fangled and newfangled intermediaries. The legacy intermediaries seem to be incensed that service providers and platforms are collecting a large share of the revenues earned by copyrighted works. They've invented a catchphrase, the value gap, to describe their complaint, which is that the newfangled intermediaries have too much bargaining power and are able to use that bargaining power to negotiate lower license fees than the legacy intermediaries believe they should pay. So publishers, record labels, and motion picture studios argue that lawmakers should change the law to tilt the playing field in their favor so that they can bargain for higher royalties. But meanwhile, they're making up for what they appear to believe are pitifully inadequate licensing fees by structuring the licensing deals to minimize their obligation to pay royalties. So if Spotify or YouTube pays copyright owners for the use of music by giving music publishers or record labels an equity stake in the company, or by paying an annual upfront blanket license fee, none of that money needs to be passed on to composers or musicians in the form of royalties, and none of it is being passed on. Our copyright system empowers publishers and record labels to behave that way because they own the copyrights and they set the terms and conditions for copyright licenses. So in a similar vein, publishers have reinterpreted extant contracts and drafted new contracts to reduce the royalty rates for digital distribution of the works they control. So in standard 20th century contracts for book and music publishing and recording, authors were paid a small percentage of the revenue for the manufacture and distribution of hard copies, and a larger percentage of the revenue for licensing the work to another business. And that made sense. The smaller royalty for the manufacture and distribution of hard copies reflected the expense of making and distributing hard copies, neither of which was implicated in a licensing deal. But when publishers and record labels license works to music and ebook distribution services to enable paid digital downloads, they insisted they only need pay the lower royalty rate designated for the sale of hard copies, and that's the rate they've been paying. So on one level, none of this should surprise us. Of course, the people who control the terms and conditions of use are going to structure those terms and conditions in ways that advance their interests. What I find notable is just how little scholarly attention these moves have attracted from legal scholars. Indeed, even though all of us are likely aware of these developments because we live in the world, if you read most of what copyright scholars have written about copyright reform, you'd come to the conclusion we hadn't even noticed that. So why haven't we been looking hard at this whole collection of issues? Recently, we've been asking collecting societies to do the hard work of managing remuneration for many small change uses. And what we've learned from that is that collecting money is really easy, and figuring out how to divide it among worthy claimants is really hard. I don't want to minimize the difficulty of figuring out a way to do that. We know there are some collecting societies that pay at least a share of their receipts directly to creators. There are others who pay owners and rely on the owners to pass on the money to creators. Others dole out the money to organizations that represent creators and task those organizations with figuring out whether and how to distribute the money to their members. Still others hold the money in an interest-bearing account until prospective claimants can agree on who gets how much, and then divide up the money according to that agreement. And finally, there are the collecting societies who don't disperse royalties at all. They use the money for good works instead. So that's really interesting. It's a really interesting problem, but legal scholars don't spend much attention looking at this problem or even figuring out which of the collecting societies take which approach. It's as if once we've provided that consumers and users have to buy a ticket in order to use a copyrighted work, we're done. So there may be some policy justification for charging fees as a purely expressive exercise, so that users will understand that enjoyment of a copyrighted work has commercial value. Now, it's wasteful in the sense that some members of an author's audience will miss encountering the work because they can't afford or don't want to pay the price, but we may make that choice nonetheless to send the message that enjoying works of authorship should not be free. But if that's why we're doing it, we should say so. If our purported reason for levying the charge is to put money into creators' pockets, it might be a good idea to look and see whether or not the money gets there. But that hasn't been the focus of much legal scholarship. So cultural economists look at these issues. Ruth Taus, who's in the audience, has written some of the best papers on the topic. But economists focus reasonably enough on economic analysis, not on the influence of legal rules. And there just aren't a lot of lawyers looking at this space. So some copyright scholars have in fact begun to ask the question whether and when creators actually respond to the rewards that are promised by copyright. They try to harness the insight of disciplines other than the law, a lot of economics, but also psychology, neurology, history, to see whether it might be possible to come up with the answer to the question, does the copyright incentive actually cause people to create more or better works than they otherwise would? But few of us have looked at the other end of the equation to see whether and when creators actually receive the rewards promised by copyright. Despite the fact that's also a really interesting question, and it's a much easier one to answer. So why haven't we been asking it? So my current best guess is that copyright experts take a lot for granted about the way the copyright system works and is supposed to work. Copyright is a property right. We're lawyers. The legal characteristics of property rights are basic building blocks of our legal education. So one element of legal property rights is control. Most of the debates over treating copyright as a form of property have in fact focused on the control that a property owner is able or should be able to exercise. Control is an important aspect of property, but it's not the only one, and it's not even the most important one. After all, we've got lots of different ways to give individuals legal control over something without giving her a property right. What makes property rights special is that they're alienable. Treating something as a property right makes it easier to sell. We define a right as a property right to encourage its transfer. And as I said, this intrinsic feature of legal property is something it's easy for lawyers to take for granted. We know that what makes it possible for publishers, record labels, and other intermediaries to behave the way they've been behaving is that the powers conferred by a copyright belong to the copyright owner rather than the author. So this strikes non-lawyers as odd, but it's second nature to us. Because we're lawyers, we know the grantee of a property right stands in the shoes of the grantor and is entitled to exercise the powers embodied in the property right. We assume the original property owner had the opportunity to extract compensation for the value of that right, because that's just how property rights work. Indeed, copyright lawyers and scholars sometimes use the terms author and copyright owner interchangeably, treating them as synonyms. After all, the author is the initial copyright owner. The person to whom she transfers those rights is entitled to step into her shoes. So for many purposes, maybe most purposes, in the eyes of the law, the owner is the author. So I want to argue today we need to take a more nuanced look at how legal property rights actually behave in the world, and we need to examine our view of legal property to identify the things that our assumptions may prevent us from appreciating. So now I'm going to take a short detour. I'm going to tell you a distinctly American story. The story, at least at first, isn't going to seem as if it has any bearing at all on copyright law, so please bear with me. The story begins about 400 years ago. In the 16th and 17th centuries, European colonists sailed to North America to develop new territories in the names of their sovereigns. The journeys were difficult. The colonists surely felt as if their travails entitled them to claim a home when they got there. Unfortunately, they got there and they discovered that the land already had occupants who had lived on that land for centuries. The European settlers moved in anyway. And sometimes it was possible for the Europeans and the indigenous tribes to coexist, at least initially. In other situations, though, the tribes occupied territory that the Europeans wanted to control. The Indians weren't white, they weren't Christian, they weren't farmers. They weren't making what the Europeans believed to be the best and highest use of the land that they occupied. And so some of the European settlements felt little compunction about seizing the land from its occupants. Violence ensued. Eventually, after enough people had been killed, enough property had been damaged, the settlements and the tribes reached agreements, dividing up the disputed territory between them. Those agreements turned out to be unstable. The European Americans kept seeking to expand their territory, and over the next 200 or so years, they used persuasion, threats, citizen violence, military force to convince or compel Indian tribes to relocate westward to more remote and less desirable land. Along the way, more violence ensued. The American army was busy conducting one or another war with Indian tribes for most of the 19th century. So American courts concluded that the Indian tribes had an enforceable legal right to occupy tribal land, but they didn't actually own it. The United States federal government came under immense pressure to open Indian land for settlement by white European Americans. It tried to use the tools at its disposal, which were money and soldiers, to move the tribes out of the way of white homesteaders. But Indian tribes who'd agreed to resettle west of the Mississippi River, only to be asked to move again, were increasingly reluctant to agree to be uprooted. Besides, the government was running out of land. White Americans resented the tribe's control of land they believed should by rights be available to them, and they pursued a variety of devices, lawful and unlawful, to wrest control of the land from the tribes. So what ended up doing the trick was a series of statutes, of which the most famous is an 1887 law called the Dawes Act, also known as the General Allotment Act. Instead of taking the land away from the Indian tribes, the Dawes Act gave the tribal land to individual Indians. The act divided the vast territories that were controlled by Indian tribes into many 160-acre individual plots and awarded each plot to an individual Indian household. It awarded it to them in trust for a short period and then in fee simple. So during the trust period, the Indian owners were permitted to lease the plot to other people, basically white Americans. After the trust period expired, the Indian household that owned the land was free to sell it to any buyer. And any unallocated plots were deemed surplus land. The federal government bought them from the tribes and made them available for sale to non-Indians. So at the time, I'm sure some of the supporters of the Dawes Act and similar laws believed it would empower individual Indians to invest them with ownership of a plot of land. Other supporters had more cynical motives. In any event, to the extent one purpose of these statutes was to encourage the transfer of land from Indian tribes to white American citizens, it was a stunning success. Very quickly, the majority of land occupied by Indian tribes passed out of Indian hands through sales to non-Indians. The winners were white settlers and land speculators. The Indians ended up impoverished and often displaced. Okay, let me draw a couple of parallels. You may find this offensive to a statute we're more familiar with. Story starts at about the same time. In the 16th and 17th century, the members of the Stationers' Company had a monopoly on publishing that was augmented by a naked horizontal restraint of trade. After more than a century controlling the publishing business, stationers surely felt entitled to continue to exercise that control. They had, after all, invested significant money and efforts in printing and selling their texts. When Parliament declined to reenact the Licensing Act that gave the members of the Stationers' Company their printing monopoly, the stationers engaged in strenuous lobbying to persuade the government to restore it. So I don't want to simplify the complex set of considerations that went into enacting the Statute of Anne, and I don't want to minimize the provisions included for the protection of universities and readers and consumers. And I don't want to suggest that many of the law's supporters didn't believe that it would empower authors. Whatever the intention, the law ended up working out pretty well for the members of the Stationers' Company. By establishing an assignable property right for authors and their assigns, the law encouraged authors to convey their copyrights to printers and publishers, who, after all, were the people with the printing presses. So the authors conveyed their copyrights to printers and publishers, and they've stayed there for the last 300 years. Rest of the world followed that model. In almost every country, authors receive copyright protection as an initial matter, but those copyrights are transferred to and controlled by publishers and other intermediaries. So in the United States, where capitalism is both our economic system and our dominant religion, courts were especially eager to conclude that authors had conveyed their copyrights to publishers, even in the absence of any evidence that they had intended to do so. That inclination has persisted. When it didn't work to simply presume that the copyright had been transferred, our courts invented the work-made-for-hire doctrine out of whole cloth. So, the moral of both of these stories is that deeming a resource to be a property right is an extremely effective way to gain control of that resource, especially when you don't have control of that resource at the beginning. When the law transforms something that wasn't formerly property into a property right, the accompanying alienability will cause control of it to flow to people who have the most bargaining power. So if you're looking to get your hands on some arable land or to regain your control of the printing of texts, creating new property rights turns out to be an excellent strategy. Sometimes the original recipient of the property benefits, sometimes not. Sometimes the world improves as a result. Sometimes it doesn't. So here's the upshot. Immense sums of money are sloshing through the current copyright system. Only a tiny share of that ends up in authors' pockets. By some accounts, that share has been decreasing. We all know that because, as I said, we live in the world. But we tend to forget it or ignore it when we talk about copyright reform. So over the past 300 years, we have expanded and extended copyright rights repeatedly. We've larded the law up with new licenses and payment obligations. We've failed pretty much to examine how or whether the intermediaries who are tasked with distributing the revenues actually disperse them. We don't look inside the black box surrounding the author's conveyance of her rights to a new owner, because we understand how property rights work. And because we understand how property rights work, we trust and assume that the profits flowing from copyright expansion will redound to the benefit of authors. But because we live in the world, we know or should know that often they don't. If we believe that's a problem, and I happen to, we won't be able to figure out how to fix it without taking a hard look inside the black box. That means asking some questions we're not in the habit of asking, and that copyright owners are not, frankly, in the habit of answering. Let me say parenthetically that maybe we don't think this is a problem. Yes, authors receive a really small share of the proceeds from their works, but perhaps we figure that's appropriate. If that's right, the fuss about the so-called value gap makes even less sense. If we believe that economics and policy support the conclusion that creators' teeny-weeny shares of the vast sums generated by the enjoyment of works of entertainment and information is just about the right amount, it's hard to see any justification for interfering in the negotiations among big commercial actors to dictate which of them gets the largest share of the very substantial remainder. And really, there's enough there for all of them to take home a lot of money. If the problem's worth addressing, though, we should have learned by now that it's not a useful solution to throw more money and control at copyright owners and trust that this time they're going to share a bigger part of it with authors. So I want to emphasize the really narrow limits of the argument I'm making. I'm not arguing that the alienability of copyrights is itself the problem, nor do I believe we could solve the problem by simply limiting copyright transfers or making rights inalienable. After all, consider Germany. Germany treats copyrights as inalienable, at least formally, but German authors don't appear to enjoy significant financial advantages over authors from other countries. I think the role that the alienability of copyright, of property rights plays in my argument is twofold. First, and we all know this, whenever we have significant disparities in wealth and bargaining power, the distribution of freely alienable property rights is almost always going to mirror and will often exacerbate those disparities. Second, the legal dogma surrounding property rights, which as lawyers we've inhaled since we were students, can keep us from appreciating those disparities. We don't pay enough attention to the use of alienable property rights as a device to allow powerful actors to appropriate valuable items in the control of less powerful actors. Okay, so that's the problem. What do we do? That's very hard. I don't have good answers. Copyright in the 21st century is a very complicated legal ecosystem. I think first, it's really important to explore that ecosystem carefully and from the inside in order to understand the reasons that it has persistently given creators short shrift. That involves taking a painstaking look, among other things, at the way that authors and copyright owners structure their interactions, so that we can figure out whether, and if so, where an intervention might be effective. So I don't have any easy solution to propose. I mean, I think I've figured out some things that won't work. Throwing more copyright rights at copyright owners is unlikely to trickle down to creators, at least unless and until we understand more of the dynamic that results in their getting such a small share of the proceeds from their creations. Adjusting the law to enhance the bargaining power of publishers over platforms or platforms over publishers isn't calculated to make life any better for creators. I don't see much promise in any of the pending statutory or treaty proposals that are currently on the table. They may solve other problems, not going to solve this one. Now, it may be that the proposals now on the table are the only ones that have any practical chance of adoption, precisely because Reed Elsevier, Vivendi, Disney, or Google won't countenance a new law or a new treaty that leaves them no better off than they are today. But we can't begin to figure out plausible alternative solutions to offer until we have a better understanding of the problem than we do now. So, I think it's possible that we could decide that there's a way to tweak copyright ownership or revise licensing rules in ways that could improve the world for creators. I suspect, though, that we may end up concluding that the most promising proposals are only tangentially related to the copyright law we know. So I can imagine requiring, for instance, that the collecting entities that don't currently pay creators' share of royalties directly to creators do so from now on. I have a colleague, Jeremy Peters, who's on the music school faculty of the University of Michigan, who has suggested we could get a lot of mileage from encouraging or requiring copyright owners to adopt generally recognized accounting standards along with the mandated publicly available annual audit. I suspect we might get somewhere by imposing labeling rules that required purveyors of copies of or access to copyrighted works to disclose the percentage of the purchase price that will be paid directly to the creators of the work. Just stick it on the package, put it on the ticket, have it on your website, see what people do. Might be useful to set up and fund government and nonprofit organizations tasked with educating and supporting creators in appreciating and enforcing their current legal rights against the entities to which they've transferred their copyrights. None of those are copyright solutions. Any of them might help. I mean, they don't come from the copyright scholar's usual toolbox, but there's value in exploring the copyright system from unaccustomed vantage points. If nothing else, it can help us to appreciate what we tend not to see and why we don't see it. And with that, I'm open for questions.